A lawyer is telling you that you can bring a rent stabilization rent overcharge case against your landlord as a class action. Should you do that? What is a class action? What are its pros? What are its cons? What are your alternatives? That's what we're discussing in today's episode. Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I'm Michelle Itkowitz, and as always, first we're going to set the stage with some context so that you can understand today's case. We need to say a little bit about two things so that you can understand today's case and today's tenant takeaway. First, we're going to talk about rent stabilization overcharge claims that are based on allegedly wrongful rent jumps taken by landlords based on alleged individual apartment improvements. Individual apartment improvements. We often call them in my field IAIs. But you know what we're going to call them today? We're just going to call them improvements, just to keep it simple. Okay, rent stabilization's around since the 70s, and it keeps the rent lower generally than what the market rate would allow the rent to be. But one way up until 2019, that the rent-stabilized rent could really jump a lot was because of these improvements. A landlord was allowed in a building that had 35 or less units to take a permanent rent increase at the level of 1/40th of the money spent to improve the apartment. Let me just give you an example so that doesn't sound like a lot of gobbledygook. If a landlord improved an apartment by buying an appliance that cost $400, then 1/40th of $400 is $10. So the rent would permanently increase by $10. If the landlord improved the apartment by spending $4,000, then the rent would go up by $100 because 1/40th of $4,000 is $100. If the landlord spent $40,000 improving an apartment, then the rent on that apartment could jump up by $1,000. So improvements were something that up until 2019, when the Housing Stability and Tenant Protection Act took that option away, improvements were something that landlords liked to do. But here's the crazy thing. No tenant consent was required if the improvements were made during a vacancy. And no DHCR approval was required either. So DHCR, the New York State Division of Housing and Community Renewal, the New York State agency that has auspices over rent stabilization, it didn't have to approve of these improvements and the extra money that it added on to the monthly rent. You might ask at this point, well, what would stop a landlord after a vacancy from telling the new incoming tenant that they just spent $40,000 or, for that matter, $80,000 and jump the rent up by $1,000 or $2,000? What would stop them from doing that if you didn't need any outside government agency approval and if it was on a vacancy and you didn't need tenant approval? What would stop every landlord from just saying they spent so much money on the apartment and taking a big increase? Well, not a lot did stop a lot of landlords from claiming to have spent that money, and that's going to be the topic of today's case. Yes, it's a bit like asking the fox to watch over the henhouse. When the improvements are questioned, how can a landlord substantiate that the improvements were actually done? Number one, signed contracts between landlord and a legitimate contractor. Number two, invoices marked paid or receipts that are contemporaneous with the completion of the work, showing that the work got paid for. For that matter, canceled checks or other proof of electronic payment, credit card statements, whatever, showing that the work was paid for. affidavits from contractors indicating that the installation was complete and paid in full. Before and after pictures or videos are always good. Any documentation from the New York City Department of Buildings. Not every job needs a permit pulled for it, but if there was one, if there was a permit and then a subsequent certificate of completion, that would be really good evidence. And then sometimes expert testimony can be brought into this too. Maybe a landlord doesn't have very much documentation. They'll sometimes try to bring in an expert who will say, I'm a contractor, I do this work all the time, here are my qualifications, and I've looked at this, and obviously X number of dollars were spent on the apartment within the last 10 years. For that matter, just the individual testimony of people who have personal firsthand knowledge of the work because they were there when it was being done. So these are the types of categories of evidence that a landlord would need to substantiate that the improvements got done if the improvements are challenged. I look at this stuff a lot. I spend a lot of time looking at whether or not improvements were done on apartments. Why? Well, I represent tenants, but I also represent landlords. But really, when I'm looking at this stuff, it's not in the category of me being hired as a litigator for either side. I do a lot of consulting on this stuff. If someone's considering buying a multifamily building and the seller is saying, oh, look at my great building and all these apartments are deregulated or all these rents are really high, the purchaser will hire me to vet what the seller is saying. They will provide me with whatever evidence they have, and I will look at it in great detail. And I'm not just looking at it in light of the statute, I'm also looking at it in light of all the case law that interprets the statute. I believe anyway that I've read every case that ever considered how to weigh this proof because it's my job. I'm also hired by banks to see whether or not they want to lend. So someone will come and say, oh, look at my great building. I got all these free market apartments in this building. And the bank will ask me to check if they really are free market. I get hired by receivers after foreclosure has started and the receiver wants to understand the building better. And I also get hired by estates. So maybe mom owned a building and all of a sudden it's yours and you want to know, are we going to keep it? Are we going to sell it? What's really here? So I can easily look at 20 apartments in depth in a week and all the documentation that goes with it. So I look at this a lot. And like I said, I feel like I've read and kept track of every case that is in this area. So what I'm going to do now is I'm going to tell you a whole bunch of ways to attack this proof that the landlord is using to try to substantiate the improvements that substantiate a big rent hike. So the statute itself distinguishes between improvements and just repairs or maintenance. So let's say a linoleum floor is all kind of dinged up and the landlord replaces the linoleum floor with another linoleum floor. That's a repair. That's not an improvement. An improvement would be putting in a hardwood floor. Last week I was looking at a building where all the work was done by Name of Contractor, Inc. I don't remember the name of the contractor. Let's just call it Name of Contractor, Inc. So I looked up the contractor on the New York State Secretary of State Division of Corporations website, and there was no company with that name or any name even close. And that website, this public website, it's easy to use. It would show if there was ever a company of that name that now just simply didn't exist anymore. If it was an out-of-state corporation, they would need to be authorized to do business in New York. So it cast some question on the documentation because contractor name Inc., there just wasn't any. And there wasn't even anything close. Sometimes the paperwork is just not great. You will have a contract or an invoice, and it might contain the address of the building, but it doesn't tell you what apartment they were working on. So that's really almost useless because it could have been any apartment in the building. Or sometimes they'll do 3 apartments at once and it'll list all 3 apartments. So you don't know how much money gets allocated to any of them. Sometimes there's a contract and it's not signed. Sometimes something is illegible. There's all kinds of just the paperwork doesn't add up. Sometimes it's discordant chronologically. You will look at the DHCR rent roll registration and you'll see that the vacancy was in the first 6 months of 2016, but this documentation supporting the work is for the last 6 months of 2016 when somebody was supposedly already living in the apartment. It's just putting the pieces together. You can often find holes where it doesn't add up. The older the improvements are, the less scrutiny a court or the DHCR is going to give them. The more recent they are, the more scrutiny. The more that was allegedly spent, the more scrutiny is going to be applied. Again, I'm getting this all from the case law. Just put those two concepts together. If the one isolated jump that got an apartment, for example, to the deregulation threshold happened 22 years ago, and it was a $200 jump that only required the landlord back then to have spent $2,000. 22 years ago, $2,000, there is precedent that's too de minimis and that will be just credited and not discredited because it's a long time ago and it's not a lot of money. On the other hand, if in 2015 the landlord needed to have spent $95,000 to have gotten the apartment to where they claim the rent is, well, that's obviously that opens itself up to the need for a lot more scrutiny. It's closer in time and it's a lot more money. For that matter, the proximity of the owner to the improvements, the proximity of the tenant to the improvements. If the owner standing in front of you, if that landlord is the one trying to justify the improvements, that's the guy who was there for the work, that guy is going to be expected to have documentation than if the improvements in question were done 3 owners ago and they just don't have the records for that reason. And it's the same thing with the tenants. If the tenant was the tenant that was there right after the improvements were allegedly done, and the tenant can say, oh, they say they spent $57,000 on the kitchen. Well, I moved in right after they supposedly did that. And I can tell you, my kitchen looked like it was from 1932. There's no way anybody spent $57,000 on the kitchen. That testimony will be given more weight than if it's a tenant who is questioning improvements that happened 3 tenants ago and 15 years ago, and they just don't possess personal knowledge of the issue. There are other factors as well. There are cases where the court will look at things like the neighborhood. I've seen phrases where the court will say, well, there's no way somebody spent that amount of money in that neighborhood. And then also just the general posture of the whole case. Are there large gaps in the DHCR registration? Are there other things that look shady? Or is this otherwise a very tight building where everything is together the way it should be? Useful life. It's right in the statute that useful life is a consideration. So in other words, let's say a landlord buys a fancy, super duper refrigerator with special ice maker or something that costs $1,000, and they buy that in 2016. Well, they can't take it out and buy another one in 2017 and add in the cost of the $1,000 refrigerator again, because there was no need. If it wasn't broken, there's no need to replace it. Things have a useful life, and that should be considered as well. All right, the other thing that you need to understand to be able to understand today's case is class actions. What is a class action? In a class action, a plaintiff sues a defendant on behalf of a whole group, a class of people. and those people are absent. They're not even in the lawsuit yet. So this differs from a traditional lawsuit where one plaintiff sues a defendant and all parties in the case are present in court. It's very unusual that you would be proceeding on behalf of people that aren't even there. So for example, a group in a class action lawsuit could be any person who ever bought a specific dangerous product. In a traditional lawsuit, the plaintiff is the single individual person or business that bought the dangerous product. But in a class action, instead of each individual person that ever bought that dangerous product bringing their own lawsuit separately, the class action allows all the claims of anybody hurt by the dangerous product. Even whether they know yet they've been damaged, all those claims are resolved in a single proceeding through the efforts of representative plaintiffs that are appointed. And you can't just decide you're doing this. A court has to certify a class. A court has to allow a plaintiff to proceed in this fashion. You need the permission of the court. In New York State, the rules on class actions can be found in CPLR Article 9. It starts with CPLR 901 and goes on from there. I'm going to give you an example. I'm friends with a lawyer who was the guy who came up with the big class action on the Happy Birthday song. Apparently, a music company claimed they had the rights to the Happy Birthday song. Happy birthday to you, that song. And every time someone would sing Happy Birthday to you on a movie or in a TV show or in a restaurant, they would have to pay royalties to whoever was claiming that they held the rights to the song. But my friend's idea was that this song was being improperly held by this company and that it was really in the public domain, meaning it should be free. The song was around long enough, or however this works, this is not my area, the song should be free. They did the case and the court agreed the song is free. So this got certified as a class action. And anybody who had been charged within a certain period of time for paying for the privilege of putting Happy Birthday in their movie or at their restaurant, those people had damages and could get the money back. So in other words, not everybody who paid whatever, I'm making this up, $500 to have the Happy Birthday song had to sue this big record company. Everybody could, there was just one representative plaintiff suing over the Happy Birthday song. And when that was resolved, everybody else could join this class and be compensated for this wrong. I think that's a very easy to understand, at least for me, example of what is a class action. And in the last decade or so, I think maybe 15 years, tenants in New York have started bringing class actions against landlords on rent stabilization issues. There's a few firms doing this, and they are very good at doing this, and they've spent a lot of time figuring out how to do this. So, for example, it's well settled that qualified plaintiffs can use the class action mechanism to recover rent overcharges against landlords who deregulated or raised the rent in contravention of the rent stabilization laws while accepting tax benefits. Let me just explain that for 2 seconds. There are certain tax programs that landlords can participate in, so they don't have to pay as much real estate taxes. Who wouldn't like that? But in exchange, there's a quid pro quo. They needed to make and keep their apartments rent stabilized. For some reason, it's a long story, landlords started not following that rule and raising the rents to free market rents even when they were still getting the benefit of the tax benefit. And the highest court in New York eventually determined that that was a no-no. You can't do that. So again, you can sort of see how this is like the Happy Birthday case. There's just one central truth and one central wrong. The central truth is you're not supposed to treat your apartments as anything other than rent stabilized with rent stabilized increases while you're getting the benefit of this great tax benefit. And if you do, it's wrong and there are damages. So everyone similarly situated could join in the class as soon as the liability was determined. That is an example of how class actions have been used on behalf of rent-stabilized tenants. I'm going to put the link in the show notes to that case that I just referred to. All right, so I think we're there. I think we have what we need to jump into today's case. Today's case is Stafford versus A&E Real Estate Holdings. It's a case from the Supreme Court, New York County, 2025. I will, of course, put a link in the show notes, and I want to remind you that Supreme Court is the lowest level court of original jurisdiction in New York. This case, which began in 2016, took tenants from several different buildings, and they have been seeking an order to proceed as a class, to do this case as a class action. And it's against the landlords and managers of many buildings. I believe there are 27 plaintiffs because there are 27 buildings. And what these tenant plaintiffs are alleging is that the owners and managers engaged in a methodical attempt to inflate rent-stabilized rents, a methodical attempt to inflate rent-stabilized rents there's a bunch of wrongs that they're alleging, but the biggie seems to be these improvements that we talked about extensively in segment 1. The challenged rent increases and improvements occurred between 2003 and 2016, with some attributable to the group that owns and manages now and others to earlier owners. But it doesn't matter because the way the law works is all falls on the current owner. To prepare to talk to you about this decision today, because this is trickier stuff, I read the briefs that went into the motion to get the class certified. I read the 73-page transcript of the oral argument before the judge. I did some of my own research. The 73-page transcript of the lawyers arguing this before the Supreme Court judge is really helpful and really fascinating in understanding what's at stake here with these cases and how important they are and how complicated they are. And it's a public record. I'm going to put a link to the transcript as well as the decision in the show notes. And if you're interested, that's really what you should read. So now next I'm going to tell you what the court held. Again, this group of tenants is asking to proceed as a class because they're questioning the rent increases, they're questioning the improvements, and they are saying that these owners and managers engaged in a methodical attempt to inflate rent-stabilized rents between 2003 and 2016. That's what their ask is. So what did the court say and why? So now what I'm going to do is I'm going to do a little reading, but I'm going to paraphrase here and there. The law's words. What can I say? The law's words. So let's just do this. All right. The court held that tenants' motion for class certification is denied. They didn't get the class. It's denied. Okay. Although tenants have creatively sought to create the appearance of a predominant common issue, the evidentiary record presented on this motion for class certification demonstrates that the purportedly common issue, that is, the existence of a methodical attempt to inflate rents, is irrelevant to the prospective class members' claims for relief, which necessarily will require proof as to the damages and liability on a claim-by-claim basis. In addition, because resolution of the purported common issue would not meaningfully, if at all, streamline the individual liability and damages determinations that would be required for every member of the proposed class, tenants have not established that a class action is superior to other methods of adjudication. All right, so now this is me commenting. I always tell people apartments in my field are like snowflakes. No two are alike. You could look at two apartments next to each other in the same building, and one could have a rent of $400 a month and the other could be $8,000 a month. It just depends on a 40-year history of what happened with that apartment. Let's go back to reading a little bit from the decision. Tenants' proposed damages referee would in fact be a liability referee as well, even assuming defendants are found to have engaged in a methodical attempt to illegally inflate rents across a number of their buildings. The referee still must determine whether each class member in fact has been overcharged, whether there's liability. Before determining damages, these liability issues include, as to each member of the class, whether the claimed improvements qualify as improvements. Remember, we just talked about that in segment 1, rather than mere repairs, and whether qualifying improvements were ever or were fully performed. Again, what we talked about in segment 1. Let's just contrast this with the successful rent stabilization, tax abatement, rent hike cases. In those cases, if there was a tax abatement in place, if you had that central truth, tax abatement in place, then it would always be wrong to treat that apartment as deregulated or otherwise raise the rent above the rent stabilization guidelines levels. It would always be wrong. So it was one determination on liability, but then you just had to look at the individual damages. That is different here, is what the judge is seeing, because here it's not one central truth and one central wrong. You have to look at each case to decide, were these improvements justified or were they not? In other words, really the liability determination is the same as the damages determination, and it's individual for each apartment. That's what this judge saw. And the judge took a long time, and that's why I recommend the transcript is fascinating reading. The judge really set time aside, spent a lot of time. He really wanted to understand. And all right, I'm going back to the decision. Because tenants' proposed issue class achieves virtually nothing in the way of judicial economy, tenants have not demonstrated that a class action is a superior means to adjudicate the class members' claims. The section of the CPLR 901A, etc., the class procedure is being proposed effectively as a procedural conduit to justify the court's oversight of hundreds of loosely connected individual claims under a single docket number. And that is not what the CPLR Article 9, the class action law, envisions. Okay, so this is me again talking. Let's just contrast this too with the Happy Birthday case. The central truth in that case was that Happy Birthday isn't owned by anybody. Happy Birthday is free. So the central wrong would be every time you charge somebody, there's a liability. So the question is just damages, where again here, finding out whether or not the landlord is wrong is the same as finding out how much the landlord owes the tenant. Having a tendency to be a big, fake, phony liar, and I'm not saying this landlord is, that's not been established yet in this case, but saying that somebody has a tendency to have not been accurate about the 27 cases you've looked at, you can't go from that to saying, well, okay, then you must have lied about 1,000 cases. It just doesn't work that way in our judicial system. It's like when your kid says, I did my homework, and you say, listen, you've lied to me about the homework on Monday, you lied to me about the homework on Tuesday, you lied to me about the homework on Wednesday, but now it's Thursday. So yeah, it makes you think that maybe they are lying about Thursday, but the only way to know if they're lying about Thursday is to check what happened on Thursday. And that's the same thing. It's not definitive until you check. A tendency isn't definitive. That's what this judge is saying. Let's do one more paragraph of the judge. In sum, although there might be some efficiencies for plaintiffs in having their claims against a common corporate defendant coordinated by a single law firm under a single docket number, as a practical matter, the litigation would proceed as hundreds of individual cases. In those circumstances, a contrived issue class to decide an irrelevant issue while leaving the determination of the merits to subsequent proceedings is not a superior method for resolving plaintiffs' individual claims. And so they didn't get their class. Now, I noticed that I looked on the court's website. I noticed that the tenants are appealing the decision. So if there are further developments on this matter that are interesting, I will keep the audience apprised. In the meantime, this brings up some really seriously important tenant takeaways. But first, let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it is just terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about, and please subscribe and give us the highest rating. It's time for the tenant takeaway. Tenant takeaway time. We are going to go through the pros and cons of seeking to attempt the class action route in a case having to do with some wrong that your landlord did to you in the rent stabilization context. And the pros and cons of your alternatives there too, so you have some useful information when making these decisions for you and your family. So let's talk about class actions. The pro of attempting a class action, if you have that option, is that you as a tenant will be represented by the absolute best lawyers in my field. The people with experience doing these class actions are undisputably the top lawyers in tenant-side landlord-tenant litigation in the city. They're great at what they do. And you're going to be getting those people for absolutely free. I saw a reference in the transcript that these people aren't even charging for expenses, and the expenses on these cases are huge. That's another thing. I didn't write that on my piece of paper here, but I'm going to add that. These are lawyers with tremendous skin in the game because they're financing these cases, and these cases are tremendously expensive to prosecute. This is a ton of work. So you get great lawyers that don't cost you anything, who have a tremendous incentive to win. That would be enough pro for anybody, but we also need to look at the cons because some of the cons are a little bit hidden. And that's what this podcast is for, to give you a peek behind the scenes so you can have the real information you need to make considered decisions about whatever it is. Okay, a con of a class action, the biggest one out there probably, is that you can't get triple damages in a class action. According to the Rent Stabilization Code 2526.7, if you're overcharged by your landlord, the landlord not only has to pay you every dollar that they overcharged, but they have to pay you triple damages, unless the landlord can show that the overcharge wasn't willful, and it's very difficult for the landlord to show otherwise. So what is this all about? Normally, in most areas of the law, if you get damaged, you can win back the cost of your damages. So if somebody cost you $10,000 because they legally damaged you in a way that's actionable, you can win an award from the court that that person has to pay you back $10,000. You lost $10,000, they have to pay you back $10,000. Certain wrongs, though, the legislature will make laws that will add to your regular damages that compensate you, your compensatory damages. They will add on to that punitive damages, punishment damages, damages that are beyond even the damages you caused the plaintiff. And they do this because they want to dissuade people from certain behavior. So in this case, the legislature really wanted to dissuade landlords from ripping off tenants. So it created triple damages, also called treble damages. So here's an example. Let's say your landlord is found to have been overcharging you for 2 years, an average of $1,000 a month. Let's just round it up. Let's say 25 months. So the landlord owes you $25,000. You paid $25,000 too much rent in the last 2 years. And that's your award, $25,000. But with this triple damages thing, the landlord owes you $75,000. That's pretty good. The problem is, in the class action context, you cannot recover the triple damages. You're only going to get the $25,000. And that's because class actions cannot be used for punitive damages. Another con of using the class action route is that you don't have as much control over that lawsuit. You might even be the representative plaintiff, but you're not in the driver's seat. Class action has a life all its own. Once it starts, you're in the passenger seat on a class action. Another thing is class actions take longer than regular court cases. You might have heard me say that this lawsuit, this class action attempt, started in 2016. This decision comes to us in 2025 to find out it's not going to be a class action as of now. That's 9 years. That's 9 years. It's 9 years to find out you can't even proceed as a class. I mean, 9 years to not even really be started with the case, that you're not even in discovery. If they had started their claims as regular lawsuits, they would be done by now. That's a tough one. And now we have a new con to class actions, which frankly, before I read this case, I wasn't telling people this. It hadn't occurred to me, but there's an element of risk here. I mean, you could wait all this time and then not get to proceed as a class, not get the permission you need. You could be denied. It's not a done deal that just because you apply for a class, fight for a class, and wait for a class, that you're going to get a class. So there's also an element of risk. Of course, there's an element of risk in anything. These are some cons, and to the extent the cons move you, let's just talk about, before you're convinced one way or another, let's talk about your alternatives to a class action, because they have pros and cons as well. You could bring your action against your landlord just simply on your own behalf as a regular case, but if you wanted to not pay legal fees, you could find yourself a contingency fee lawyer. There's people out there that work on behalf of tenants on contingency fees, and a contingency fee means that you don't pay the lawyer, but if the lawyer recovers anything on your behalf, he keep a percentage of that, usually 1/3. To go back to my $75,000 example, in that case, you'd get 50 and the lawyer would get 25. So that seems pretty good because you didn't have to pay any money up front. And again, that lawyer has a certain amount of skin in the game because he doesn't get anything unless he wins. I would argue that a contingency fee-based lawyer is not nearly as incentivized as a class action lawyer, again, because a class action lawyer is spending money on what they're doing because it's such a big undertaking. But the con really with contingency fees is that I think contingency fee-based cases in the landlord-tenant context can be weird and problematic. Contingency fees work great for things like personal injury cases. So if, God forbid, you break your arm in a car crash and the other driver is found to be at fault, there's no way that other driver or his insurance company can compensate you other than giving you some money. They can't give you a new femur. They can only give you money. So a lawyer taking a percentage of money in a personal injury case makes perfect sense. But in the landlord-tenant world, cases can be resolved in many ways that are good for the tenant that are good for housing that don't involve a big check changing hands. Maybe the landlord offers the tenant years of free rent as compensation for an overcharge, or maybe the landlord offers the tenant a brand new rent-stabilized apartment at the same exact rent in a better building with a doorman and an elevator as compensation instead of writing a big check. Landlord-tenant cases are about housing, not just about money. So there are other ways to make a tenant who's been wronged whole. But if you have a contingency fee-based lawyer, I guarantee you they are going to try to talk you out of anything other than the big check. That is what they need for their payday. That's just something to keep in mind. Okay, here's another alternative. You could pay hourly legal fees. You could just pay a lawyer to bring the case on your behalf. No class action, no contingency. Now, I guess the pro here is that you have maximum control. And if you use my earlier example, then you're keeping, if you win $75,000 with your triple damages, you're keeping $75,000. But before you get too excited about all that, here's the thing. You are paying the lawyer. And good lawyers who understand New York City landlord and tenant cost money. And if you had any doubt that I wasn't sincere about this not being a commercial for me, that doubt will be dispelled with my next sentence. If you used me to really battle with your landlord and get you a $75,000 overcharge award, you probably have paid me $75,000 to get there. So in a way, that's net zero, making that the worst choice. So you might ask, why would anyone ever use you for this, Michelle? But my bailiwick in New York City tenants is less about the overcharge awards and more about pushing free market apartments back into rent stabilization. So I usually give this example. I represented a very successful independent filmmaker, and she paid me about $65,000 over 4 years to use the court system to push her apartment back into rent stabilization. And I got her also a $110,000 overcharge award, and her free market apartment turned into a forever affordable home. So, pushed her back into rent stabilization. Her monthly rent was reduced by $600 a month. So that client obviously was happy with me, but that client had $65,000 after-tax dollars of disposable income to spend on a lawyer over a 4-year period. And not everyone does. If the private lawyer who's paid on an hourly basis isn't successful, then you've spent the money and got nothing. So there's risk there as well. We're going to look at one more option, which is go it alone at DHCR. You can bring a case at the New York State Division of Housing and Community Renewal, which again is the state agency that has auspices over rent stabilization, and it has an adjudicative arm for overcharge cases. And you don't need a lawyer. You can have one, but I don't think it's necessary. There's no court appearances are necessary. It's all done on paper, and there are no filing fees. So you're not paying anybody. Now, what are the cons? Well, obviously, you're not working with a lawyer who knows this stuff, and this stuff is hard. But, and this is where I really want to be careful, it's hard, but it's also not rocket science. There are publications at DHCR, fact sheets that will help you. I'll put links in the show notes. And also, I have to say that if you just go back and listen to segment 1 of this podcast with the 10 different ways that I told you that are contained in case law and statutes and just my own experience of pushing back on a landlord trying to establish that they did the improvements, if you just took all that to heart, you literally know more than most people working in housing right now. Legal aid lawyers are excellent. They would know this stuff. And again, like I said, these people doing these class actions, they know all this. They're top notch. That level of knowledge is generally held by people who do this all the time. So just take that list and start attacking the landlord's proof to the extent they even have any proof. Again, pros and cons, pros and cons. Here's another con on the DHCR part of it. if you win your DHCR case, your landlord will probably appeal. Now, there's an internal appellate level called a PAR, Petition for Administrative Review at DHCR. But then the appellate process can take the matter out of DHCR eventually to the court system in what's known as an Article 78. So you could end up in court. If you're too successful against your landlord will eventually appeal and it gets to court. But at that point, if you're paying a lawyer, it might make a little more sense because it's almost like you have proof of concept. You beat your landlord at 2 levels at DHCR, and so maybe now this is worth putting a few bucks to a lawyer. Again, these are just the considerations. It took me a long time to produce this episode because, again, I had to read the decision, the briefs, which were long, the transcript of the argument, which was 73 pages. I had to do some independent research, and I had to really try to figure out how to explain very hard material to a non-lawyer audience, but that's always my job here on this podcast. I think what was really holding me back, however, was I wanted the tenant takeaway to give more definitive answers, but there is no definitive answer here. Your options are all less than perfect. What people, when I say people, meaning landlords and lawyers, and even lawyers for tenants, often don't understand is that tenants are not making business decisions on these cases. They're not making business decisions, and that's because your housing is not a business decision. Of course, there are economic aspects to your decision. For sure, there's economic considerations. But housing is a personal decision. It's not a business decision. So, for example, you might have the money to afford a good private lawyer, and you might have the appetite for risk involved with hiring one. But if your partner in life and in your housing, a person who you make decisions with, doesn't agree, then you're not hiring a private lawyer. Maybe you don't have any of those impediments, but you're strongly socially justice-minded. You might want to go the class action route, even if you have every other option, because from a social justice point of view, you might want to be thinking that your efforts are helping as many people as possible. In this particular case, the tragedy of it is that there's the 27 plaintiffs, and now they can't proceed as a class unless this gets overturned on appeal. But also, that they were saying that they think there's 1,000 other people out there, or maybe more, literally 1,000 people in these buildings now or who had been there in the past that would be affected. So some people just might make the decision based on how they think they can do the most good, and that's probably the class action. Then again, there's people out there who really like this stuff. Sometimes people contact me and they've done so much research, and they do know more than some people claiming to practice privately in the housing area, and they are perfectly equipped to do it themselves at DHCR. And then there are people who hate this stuff, and if they do, they probably haven't listened this long in this podcast anyway, but they don't want to do any work. They don't want to wait for years to see if a class is certified. They don't want to pay a lawyer. So a contingency fee-based lawyer works perfectly for them. Whatever you do, just ask your potential lawyer, if you're going to work with one, these questions. Just listen to this, maybe listen to it another time, write a list of questions, and ask your lawyer. And if you're going to do a class action, ask your lawyer if they've ever gotten a class certified for the specific issues that are involved in your case. This case sounds to me like these lawyers have had a lot of success with the class action vehicle, and maybe this time they just pushed it a little too far. Maybe not. The appellate court maybe will tell us differently. Who knows? People have all kinds of reasons for making their housing decisions, and my self-appointed job here is to tell you what no one else will. So now you have some more information to help you sort through these difficult choices for you and your family. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I'm Michelle Itkowitz, and this is the Tenant Law Podcast.